We are live.
Namaste. Good evening to everyone. Welcome to the fifth day of lecture in the sixth edition of MyBHARAT Lecture series by Disha Bharat. I am Monisha Rajshekhar, a final year law student at MS Ramaya College of Law, and on behalf of Disha Bharat, I will be acting as your host for the day. Today, I wish to introduce you to the concept of internships at Disha Bharat. As classrooms evolve, teaching is no longer confined to textbooks and lectures. True learning happens when students actively engage through discussions, debates, and peer interactions. But to truly prepare for life and global career, theoretical knowledge alone is not enough. Recognizing this, many educational institutions now encourage students to pursue internships in industries and NGOs, where academic concepts come alive through real world experiences. In line with this, Disha Bharat today offers students valuable internship opportunities that promote experiential learning and meaningful community engagement, helping them gain clarity, confidence, and direction in their life journey. Coming to the My Bharat campaign, it's a pride and honor to be welcoming and introducing today's speaker, Shri Aruna Shyam sir, to all of you. Aruna Shyam sir, the designated senior counsel at the High Court of Karnataka, is a distinguished legal professional and a former additional advocate general of Karnataka. He serves as an academic council member of the National Law School of India University, NLSIU, and is widely recognized for his work in matters concerning Hindutva. Having provided extensive legal aid to nationalists and matters concerning Hindutva, he's provided extensive legal aid. Beyond his career, he's also known as an active social worker and was recently honored with the Dharma Ratna Award for his dedicated contribution towards the causes of Hindutva. Thank you for joining us today, sir. Waiting to hear your insights on the role of judiciary in shaping Bharat as a global champion of democracy. You come with such a rich experience in this subject, and we're eagerly waiting for your insights on this topic. You will now have the floor for the next 40 minutes, sir.
Thank you, Nisha Rajshekar. Good evening, everyone. Respected Disha Bharat team, especially Madam Rekha Ramchandran, Founder Secretary, Amita, and others, ladies and gentlemen. I have been assigned the task of speaking a topic called Pillars of Democracy in India and the role of the judiciary in making Bharat as a global champion of democracy. To begin with, we should understand what is democracy. Then we can understand the role of judiciary. Let's start with Dr. Baba Sahib Ambedkar mentioned about democracy. He said, and I quote, democracy is not merely a form of government, it is primarily a mode of associated living. So we are all living together in a society where it is a form of government by the people, of the people, and for the people. That means we ourselves constitute a government. We are the government. We ourselves constitute a government, and this government is for us only. But this democratic setup, it should require a structure to stand. That has been embodied by way of constitution. That is why we call it as pillars of democracy. So to stand strong, it must rest on pillars, each supporting the weight of liberty, equality, and justice. When we think democracy, the first image that often come to our mind are election, voting line, rallies, and political speeches, code of conduct, all these things. But democracy is far more than ballot box and etc. Democracy means the rule of law, the protection of individual rights, and a constant system of checks and balances. The Bharat or India is the world's largest democracy. It is our pride to say that the responsibility is heavily on the judiciary. Of course, the responsibility is equal when we say that all pillars are equal, but judiciary has got something extra to do that we will examine how it plays a crucial role. In democracy, legislature makes law, executive implements it, and judiciary guards its soul. So India being the largest democracy in the world, the pillars are not just theoretical concepts, they are living institutions that affect our daily lives. Judiciary is standing as a guardian of constitution, protector of our liberties, and reference uh, between the powers of the states. Because so many things needs to be balanced in a country like India. Today I want to explore with you how the Indian judiciary has shaped the democracy and the Bharat's journey towards becoming a global champion of democracy. Uh, at the end of talk, I hope we all see the judicial independence is not just a necessity; it is the heartbeat of democracy. We will understand. Before that, let us explore what are all these pillars, and if I ask a question, can anyone name what do you think? What are the main pillars of democracy? The answers will be legislature, executive, and judiciary. Then we call media or press as the fourth pillar. Each has got its own importance. Each has got its own relevance and role to play. Uh, when we got independence, the constitution we gave into effect. Under the umbrella of constitution, we divided all these pillars distinctly and differently and entrusted different tasks for the development of or for the welfare of the citizens of the country. Now, the academicians and the modern thinkers say there are two more pillars, what we can call that is civil society and election commission, because they also play an important role in our democracy. So we will be examining altogether 6 pillars. But among these 6, I would say judiciary will be the middle pillar which balances and strengthens the democracy. Now let's see what exactly the role by the legislature. Legislature is here to make laws, policies for the nation. The representatives of the people, the after the mandate by the electorate, the party which is in power or the ruling party or the which forms the government will bring the policies for the citizens. That whatever law that is brought under the umbrella of constitution will be the laws of the country and even the policies for that matter. So the legislature is entrusted with the duty of bringing the law, and such laws will be applicable to the, if it is a central law made by the parliament, it will be applicable to the country. If it is state legislation, then it will be applicable to particular state. So this is how the legislature brings law and policy and governs through the next pillar, that is executive. So here there are many challenges if we speak about the legislature, the lack of debate in important debate on important bills, then criminalization of politics, then corruption. All these things are there, but at the end of the day, the legislature has got its own role to play. For example, sometimes even some of the judge-made laws can be overruled by making or bringing in some legislation. There are many such examples where if the court makes any judge-made law or legislature in the absence of some legislation, if court gives some direction, there are incidents where the court's rulings were nullified by legislation. That there are such situations, no doubt, but legislature has got its own role in bringing legislation and policy. That much we will focus for the present. Then the next is executive. The whatever laws or the policies of the legislature, whatever will be executed or implemented through administrative mechanism. We can call them as bureaucrats. They will implement or they will take to the grassroots the whatever the projects of the governments or schemes, policies or law, whatever. At the union level, we can say president, prime minister, council of ministers, then civil servants. This total setup will form the executive, where the execution will be done through the civil servants. At the state level, governor, chief minister, then the minister of state, and the officers or the bureaucrats in that again as a implementer, they will come into picture. Then there are many policies and maybe central or state, depends on the situation, that will be implemented. So after the executive, the next important pillar will be in the democracy is judiciary. A independent judiciary is important for the purpose of protecting the constitutional morality, constitutional values, fundamental rights. Then altogether we can say democracy. The independent interpreter of the constitution and the laws, the judiciary plays a vital role. We will examine in detail in the second part. Now we are examining what are all the pillars and how these pillars are strengthening the democracy. That is what we are examining now. In the second portion, we will go into detail about the role of judiciary. So the court will strike a balance. It will interpret the law. It will conclude certain issues, and it will set right the conflicting whatever conflicting disputes or issues. So judiciary has got many more role or much role to play that we will come to later. Then the next pillar, what we call is media or press. All we know, the traditional media is different, the present generation media is different. If we talk about media, the traditional media is only print, and then later it developed to electronic. Whatever comes in the media believed to be true, and that is why it is called as watchdog of democracy. But the development in technology and the development in the generation or the changes that taken place now has come to a stage where there is one more media called social media. But so far as media is concerned, there are regulations. They are registered under one or the other laws. But so far as social media is concerned, nobody can restrict them. There is no prohibition. There is no restriction. And this is really a challenge. This is really a threat. This is really an advantage also. So now people started believing social media blindly because seeing is believing, what we used to say. Now, because of the social media activism, each and everything will be in the web. Now, along with the Right to Information Act, whatever the affairs or whatever the information, whether it is pertaining to legislature, executive, or judiciary, whatever is amenable to the public, and through social media, it can be brought to the notice of the public. So earlier, when we talk about media, there were certain, as I said, restrictions. So far as the present generation, there is no check and balance. Of course, Article 19(1)(a) provides freedom of speech and expression, but there is no one to restrict the media. Therefore, a fair media and transparent media and ethical media should be called as watchdog. But there are instances where false propaganda, fake news, then now this reels, whatever the present generation things are coming up, they are certain, they are creating certain disturbance also in the society. But court can or judiciary can regulate to a certain extent by way of granting injunctions or granting certain postponement orders. That also we will examine a little later. But so far as the executive is concerned, on the basis of the existing laws, certain cases that will come in the way of freedom of speech and expression is criminal cases that can be registered either for defamation. A private person who feels aggrieved or defamed can file a defamation complaint. That is one aspect. The other thing is uh, promoting enmity or hatred or making certain imputation against the national integration or hurting religious freedom, what we can call as that is earlier in Indian Penal Code it was 153A, B, then 295A, then 505. So presently that BNS is in place, section 196, then 197, 299, 353. They deal with the situations where if people intentionally incites a particular community or religion, or if they make hate speech, that can be a subject matter of criminal case and FIRs can be registered. But again, that has to be tested in the court of law when it is under challenge, whether the words uttered or the picture shown or whatever disclosed through by way of a hate speech or alleged to be a hate speech fits within the parameters of Article 19(1)(a) or not is the question that task also will be looked into by the court of law. The next important uh, pillar that, as I said, civil society. How a civil society can be one of the pillar of the democracy is the aspect we are now just having a glance. For example, as a electorate at the electoral college, we cast our vote. That is one aspect. If the elected government makes any uh, mistake or if they commit any crime, if they commit anything which is contrary to the expectations of the people, then people will agitate. They can hold strike, hartal, they can mobilize, they can organize protest, rallies, dharna, and such right is also conferred on the public. So a educated or well organized civil society is the next important pillar where they can question each and every thing or every mistake or anything, either by a hartal, band or public movement. That can be individual or that can be a collective movement by way of fundamental right. There is a fundamental right called right to association. By virtue of that right, you can organize any hartal, band, or you can through a NGO, non-governmental organization, you can create awareness. What exactly Disha Bharat is doing, you are creating awareness among the people about the constitution, burning issues, national importance issues, same thing. So therefore, as a important pillar, the civil society collectively or individually forms a definitely a strong pillar. Then the next one is a election commission or a strong regulatory body called election commission. A free, fair, and transparent elections at all levels needs to be conducted. It should regulate the political parties, mighty power, uh, mighty power centers. It should control. And once if a model code of conduct is in place, it is like a partially imposing a restriction on the certain freedoms. So that is one aspect. The other aspect is the entire government machinery will be regulated, controlled by the election. Rather, they will take over. So this is one aspect that the election commission will do. So a strong election commission. Now EVMs are there. Now fair and transparent elections are conducted. There are challenges to the various aspects, but election commission is one of the strong pillar, I believe, is to hold the judiciary or the importance of the importance of the democracy. So election commission, for example, during elections, they will take over everything. A minister cannot use any state machinery. A government official don't have privacy or you don't have liberty of uh, staying in a particular post if it is he has stayed for more than beyond or beyond 6 months. So this is how the election commission also play an important role. Now the challenge before the election commission is holding elections, that is uh, Lok Sabha, then the state elections, then this three-tier system at panchayats or local body elections. So this is one of the biggest challenges before the democracy, particularly in our country. The election commission is facing this. So solve this or to get over this, now there is a concept called one nation, one election. If one nation, one election comes into operation, so many advantages are there, but political parties may say they have disadvantages rather than the advantages. The advantages are like this. The unnecessary burden for exchequer, the financial, the time constraint, then uh, security, the administrative adjustments, huge control or fund, imposing the one again and again this code of conduct, etc. That will be taken away, and the people will have only once in 5 years, more particularly, may have the right or duty of voting or contesting or facing election. So this is one aspect so far as the union and the state is concerned. So far as the local bodies also are concerned, why can't the nationwide Election Commission hold election together is another aspect that has to be examined. And to implement one nation, one election, at least we can suggest that let them implement one nation, one election for the local bodies first, because for Gram Panchayat, that is Taluka Panchayat, then Jilla Panchayat, the corporations and other bodies, why can't, as a trial basis, implement it? That is also one of the aspect to be considered. If the elections are held together, lot of money, time, etc. can be saved. So, as I mentioned, the election commission plays an important role. But again, among all these pillars, if the conflicts or any dispute arises, then the judiciary will be the final authority, and judiciary will only be protector or balances this conflicting power. So this is how the judiciary's role comes into the picture. Now we will come to the second part, that is to say role of judiciary in making the country a global champion democracy, where the judiciary's first and uh, important aspect or the role is it acts as a guardian of constitution. Uh, when we adopted constitution in the year 1950, it is not just a legal document, it is a moral and political compass of our nation. More particularly, Article 32 and 226 were introduced in order to protect the fundamental right and to hold judicial review of the other maybe law or the executive actions at the High Court level or the Supreme Court level. These power of the High Court or Supreme Court under Article 32 or 226 is called as power under writ petitions. Is called as writ petition or writ power, where the writ petitions can be filed in order to either to uphold the constitution or the supremacy of law, then executive actions, if there is any violation of principles of natural justice, or if there is any, if there is no remedy at all, then also writ petition would like. But these writ petitions are available against the state and its instrumentalities, whatever defined under the constitution. So these Article 32 and 226 play a vital role to as a guardian of the constitution. We can very well give example of Keshavananda Bharati case, where Supreme Court upheld the or laid down a concept called the basic structure doctrine, where Supreme Court said what can be amended, what cannot be amended. There, democracy, secularism, rule of law, separation of powers, these are all the bedrock of our constitution, or it is a basic structure of our constitution. These structures cannot be amended. This is what the authoritative pronouncement in the case of Keshavananda Bharati. There were 13 judges sitting in that. It was a judgment out of 7 and 6 ratio. Then the next one is Indira Gandhi versus Rajnarayan. During emergency, this case propped up, where the Prime Minister is held to be not above the law, and the election malpractices were declared as a disqualification, and because of that, a unwarranted emergency was invoked. That is a period where 75 to 77 to take over the situation. The emergency was unwarranted, but it was invoked. And during that period, the courts were little, we can say they were not active, but they could not do much. Because in a case where ADM Jabalpur, since the civil liberties are suspended, court found it helpless. Probably the very process of invoking emergency at that point of time was not properly challenged. That is what I feel. Because nowadays, for each and everything, people will file a PAL or file a writ petition challenging the action. Recently, when Article 370 issue came up, where it was filed, it was moved. Then, when the farmers' policy introduced, or that law was amended, they filed writ petition. Everything, whatever now the government comes with the new policy or law, that is being the subject matter of challenge. I feel during emergency there was no proper challenge to the very invocation of emergency. If it is the present state, present generation, it would have been a different scenario. That's what I feel. Later, the courts have gradually developed Article 21, the right to life, not a animal existence. Then it is a bundle of rights. From Maneka Gandhi till recent right to privacy and all. The courts interpreted the scope of Article 21, and that is why this right is a bundle of right or vast right. It can be stretched to any extent. So, right to reputation is a right to speedy trial is a fundamental right. Right to fair trial is a fundamental right. Right to transparent and speedy investigation is also a fundamental right. There are many such dimensions given by the court, law courts in various judgments. So, next aspect is the judiciary as a protector of fundamental right. As we see, the expansion given to Article 21, the judiciary also started activism and started examining the rights in detail. So, in the case of DK Basu versus State of West Bengal in 1997, Supreme Court laid down detailed guidelines to prevent custodial torture, deaths, holding that the abusive violates the right to life and personal liberty under Article 21. Subsequently, there are many judgments, but I will only refer few. Shreya Singhal, Union of India, that is 2015 judgment, where Section 66A of the Information Technology Act was struck down as it interferes with the freedom of speech and the privacy. Even this has been appreciated and elaborated in the case of Justice T.S. Puttaswamy versus Union of India. A retired judge filed a petition wherein which it was held that right to privacy is a fundamental right. So, this right to privacy is playing a pivotal role in the modern era of we are now in 5G or 6G, that era where everything is considered as either digital or web world. So here the privacy of somebody is important, and whatever contrary to or with whatever affects somebody's privacy is held as unconstitutional, and for that the remedy would lie before the court. The next judgment, if we can discuss, that is about Navtej Singh Johar, where the same-sex relations and the the section 377 of Indian Penal Code that has been neutralized by saying it is not a criminal act. It is the personal right of the uh, citizens. So this is one of the recent development. In 1997, Vishaka versus state of Rajasthan also played a vital role. Uh, there were harassments in the workplace. There were no proper act enactment or guidelines. Therefore, court stepped in and gave guidelines till the formation of the law. These guidelines will be operating. That's what the Supreme Court said. And based on the directions, laws were framed subsequent to the legislature. Then the another case we can examine here is National Legal Service Authority versus Union of India, where the transgender rights were upheld and that is protected. The next one is so far as People's Union for Civil Liberty versus Union of India, where NOTA, first time the courts recognized a concept called NOTA, none of the above. That means other than the persons whose name mentioned in the ballot paper, that is to say, it is an embarrassment and it is an lesson to the person who contested for the election to say that there are persons who said none of the above. So this is one of the latest trend NOTA concept brought into picture. Union of India versus Association for Democratic Reforms, they their Supreme Court issued some guidelines. Those who are required to contest in the election to disclose their financial, criminal, and educational backgrounds, so that electoral college will know what exactly the profile of a candidate, what exactly the ability or the talent of the candidate, because unless it is disclosed to public, the people will not be able to know about them. Therefore, right to know is also held as a fundamental right, and that this right uh, has been recognized for the first time in this case, and guidelines were issued, and it is mandatory now to file a detailed affidavit. During COVID, also Supreme Court as well as the High Court, respectively, dealt with the challenges faced by the COVID. To give example, in Karnataka High Court, lot of measures were taken by the division bench headed by the then Chief Justice Sri Abhay Srinivas Okha and Honorable Justice Arvind Kumar. They arranged free trains for the labor class to the migrant labor class to go back to their places. Then oxygen supply issues, then hospital bed and minimum charges, etc., were all regulated and controlled. And to get over the COVID situation, the judiciary stepped in and played a vital role. The next aspect, what we can say, social and economic rights, where the certain issues were burning, certain issues were form of a corrective measure, or it should have been dealt by the legislature or by the people at their instance, but that could not be solved even by mediation. For example, M. Siddiqui and Mahant Suresh, that is famous judgment called Ayodhya issue, that has been resolved by the Honorable Apex Court. Then Shahira Banu case, where the triple talaq practice was struck down as and held as unconstitutional. Then the case of Uma Devi, where the backdoor entries were prevented, and then the other aspects like uh, uh, using the skills or the services of the public servants for a long time and then throwing them out, that practice was deprecated. These are all the some of the judgment, and the another important role that is taken care by the judiciary is uh, that is called uh, climate democracy or environmental jurisprudence. The courts have stepped in many occasions to protect the environment, safeguard the health and the weather or pollution, etc., by various directions. Earlier, the courts were not active, but there are instances where courts interfere and give directions to maintain a pollution-free air, water, and to prevent the soil pollution. So, sustainable development and other concepts are all coined by the judiciary only. There are legislations, Water Act, then Air Act. The pollution acts are there. The Green Tribunal is also there. But still, court is at duty to intervene and safeguard the environmental interest. Major part will be taken care by the uh, judicial review as well as the uh, judicial activism. These are all the two concepts which requires to be mentioned here. One is judicial activism. Judicial activism is a very essential part where court can give direction, interpret law, uh, and give certain benefits to the weaker section, safeguard their interest. Those are all called as uh, judicial activism. PIL, public interest litigations, are one of such area where the judicial activism taken care of the country, and that is and protected the rights, then interest of the citizens. The judicial review is a corrective measure against the administrative actions or uh, the mistakes whatever committed either by the legislature or by the executive. The judicial review and judicial activism both are most important duty taken care by the judiciary in the administration of justice. So, the another aspect, if we say in a democratic country, the power balancing aspect is most important thing. For example, the center and state, there are a number of states, there are union territories, there will be interstate dispute. Interstate dispute in the sense it may be a water dispute, it may be a language dispute, it may be a border dispute, whatever. But who has to give final authority? That is the task of judiciary. Judiciary will be settling the disputes among the state, center, and among the states themselves. Because India is a federal system of democracy where union and state. So always there will be rift or tussle between the union and state or among the states. So this has to be balanced, and even a balance between the other pillars also come under uh, come under the umbrella of democracy, that has to be taken care by the judiciary. So uh, judiciary has got uh, duty to uphold the rule of law, ensure the supremacy of law, and the predominance of legal spirit. Everything should be uh, taken care by the judiciary. So, in a country like India or Bharat, judiciary play an important role uh, in safeguarding the liberty and the rights of the individual. Altogether, the judiciary will contribute in its own way to make the country a global champion. There are aspects like or challenges in the judiciary also, but that has to be taken care in one or the other way. For example, there are pendency of cases. There are four more cases as could be seen from one of the report recently. So justice delayed, uh, justice denied principle is there. But all said and done, judiciary plays an important role. Uh, the independence of judiciary was also sometimes called in question, like NJAC was one of the attempt which was brought to uh, take away the collegium system of appointing judges. That was struck down by again by the High Court, struck down by the Supreme Court. Then lot of other challenges like modernization, digitalization, then this online hearing, though it was brought during COVID, not effective. There are other challenges, but still we need to overcome the challenges, and we are overcoming the challenges. And the judiciary is safeguarding the life and liberty of the citizens. So, with these words, uh, I'm at the end of my talk today, and I hope and trust that the judiciary will continue to be a strong or a rather a great pillar in our democratic country and take or it will lead us to a champion of democracy. I thank you all for this wonderful opportunity to share a few thoughts. Uh, Thank you, one and all.
Thank you so much, sir. That was truly a thought provoking talk, and your insights have given us a very deep understanding of how the judiciary shapes Bharat's democratic journey. It's not just an institution of justice, right? But it's a guardian of the constitutional values as well. So, with your permission, we'd now like to ask you a few questions so that we can explore some of these ideas even further and learn from your vast experience.
Yes, please.
Firstly, how can the judiciary balance its role as a protector of the constitutional rights while also supporting Bharat's vision of becoming a global leader in the democracy?
It's a very valid question. I should try to answer this. Uh, at one hand, the judiciary protects the fundamental right, protects the constitutional values, or the rather under the umbrella of constitution, it deals with the issues coming before the court of law, or to say whatever the issues comes before the court. That is one aspect. The landmark cases dealt by the Honorable Supreme Court is being cited in the other countries wherever the uh, democracy is there, and the countries started taking the example from the Indian jurisprudence or judiciary or the pronouncements. Our judgments are being cited in the uh, other countries. This is how the Indian judgments are interpreted and utilized by the other countries. When the when we got independence, Western or the thinkers or people at large were laughing at India, saying we have so many problems. We have social evils, we have poverty, we don't have proper education, lack of education, we don't have any transportation. So many problems were there. We got independence. As a independent country, we decided to have democratic form of government. So that is why everybody was eyeing at India or Bharat, saying India will fail as a democratic country because of these problems. And the union of the states itself is a difficult task. But we, as a democracy, we are successful. And now we are the best example since we are the largest democracy. And we stood, we celebrated successfully the 75 years, or we are reaching our target at 2047. We are going to be a superpower. So, in this context, as I pointed out, I only pointed a few judgments and occasions how the judiciary dealt the situation and contributed for the uh, welfare of the democracy. But the important aspect is our judgments and our decisions or our democracy being cited and appreciated in the other countries. That is why we are the champions and we are the role models for them. Hope I made it clear.
Yes, sir, absolutely. Thank you. Secondly, given the rise of technology and AI laws, how can the judiciary adapt to address these new challenges to democratic governance and justice delivery? Also, sir, can the judiciary give any judicial decisions to the legislature in such cases?
No, definitely. That is what I mentioned earlier. If the legislature travel beyond the constitution, or if any law which is brought ultra vires or which is contrary to the constitution, that cannot stand. Courts will strike it down. The power of legislature is available, but they have to enact a law within the parameters of constitution. That is why the basic structure principle, fundamental right, they should not touch all these area, or they should not curtail these rights. If the legislature comes with any law or policy which violates fundamental right or which affects the basic structure, such rights are such laws or policies cut down. So uh, the the legislature will check and balance the power of the judiciary will check and balance the power of legislature in that. Now, the other aspect is AI technology and all. As and when the technology developed, now there are AI technologies available where it will be useful for the functions or the role of judiciary. So AI can contribute, can do research. The earlier, in a traditional method, people used to read books, uh, the law journals, or the digest, or the commentaries. Now AI will provide everything. It is easier for the judges, lawyers, or law students. Law students can prepare their papers easily now by making use of AI. They need not make research sitting in library. Everything will be in their fingertips. Same thing, even for judges and lawyers also. The task is easier. So the time will be saved, energy will be saved, and it is AI will be contributing more in the growth of democracy through judiciary.
Absolutely, sir. AI makes the research part of it so much easier for all of us. Next, one of the most popular questions that any lawyer, advocate, anybody in the courtroom listens to, sir. How to solve the issue of pendency of cases in the court?
This is a very tough question. Even uh, the law minister or the chief justice may not be able to answer it, but I will try to answer saying there are alternative dispute mechanism. Uh, See, for example, the Gram Nyayalaya system that bill was introduced and that is not implemented. So for local issues, uh, That should have been one of the uh, resolution mechanism that is not brought. The alternative dispute mechanism like conciliation, arbitration, then mediation. Lot of mediation and this series of campaign for dispute mechanism is going on. The Supreme Court and High Courts are taking it as a drive to solve the dispute through the settlement way of amicable settlement. So this is the other aspect, and the another aspect is the lack of appointment in time. Whenever the posts are vacant, due to administrative reasons, appointments are not being done, and there is a need to increase the strength appointment for judges. Only limited number of judges are there. Litigation ratio is high, so therefore that is also another track. And so far as the appointment of infrastructure is also required. So as we grow, the infrastructure should also be made available. Then there should be vacancies created, and that should be filled on time. Then the litigation should also attain finality. Uh, for example, the major litigator, the party in the dispute or in the cases pending is state governments. What they do is, for each and everything, they will file appeal. They want to take it to logical end. They don't want to uh, accept a judgment because they don't want to take risk. Every bureaucrat will say file appeal and get a finality from the court. Nobody will take risk and say even if we file appeal, the appeal will be dismissed. Even at the stage of Supreme Court, also it will be dismissed because many of the cases are covered by the judgments. But still, they don't want to take responsibility because they will be in a delicate situation. Today, if one officer says this is not a fit case for appeal, the another officer who is a senior or who comes to that post tomorrow or after some years may raise a query and say that officer has committed mistake by giving opinion that this is not a fit case. And there may be a case under Prevention of Corruption Act or any other law saying the officer has favored somebody or he might have colluded with the party. So nobody want to take risk. So this will add on the litigation. Some of the cases should attain finality, and the officers or the executive bureaucrats should be given some protection to put an end to the litigation. So these are all the mechanisms which may reduce the litigation.
Yes, sir, great. I think we can use all of these arguments the next time somebody asks us it. Last question, sir. To what extent should the judiciary intervene in matters of religion, and how can it balance the constitutional principles with respect to religious freedoms?
Probably we may need 2 or 3 sessions to answer this question because right to religion is also a fundamental right. But that again, that should be within the parameters of the constitution. It will be affected by the other rights also. So a recent 2 judgments, we can say Shani Shagnapur case, where the right of woman was granted by the Supreme Court, saying they can also go and offer puja. In the case of Shabrimala also, uh, overcoming the traditional practice or the emotions and sentiments, Supreme Court said even woman can go to Shabrimala. That was totally contrary to the belief and the practice. So that matter now pending before the Supreme Court, before the larger bench in review petition. So this is one of the aspects which has to be considered by the Supreme Court. Uh, so also the case of hijab, whether it is an essential religious practice or not, was the question before the Honorable High Court of Karnataka. Karnataka High Court said it is not a essential religious practice. The religion will not vanish if that practice is not followed. Therefore, it is not essential religious practice. That was the test applied by on the basis of the decided case clause. So, uh, Karnataka High Court said wearing hijab is not mandatory to those who are practicing the religion. Now, this matter is also under appeal. There was a split verdict among the two judges. So this will be now decided by the larger bench or separate. We may have to wait and see. So the scope of intervention so far as the religion is limited. The secular activities and the secular and other activities can be regulated, not the religious activities. The religious activities, the right to religion includes two things. For example, if a temple is taken into example, there are administrative function, then religious function, performing puja or jatra, festival, etc. These are all the religious part or uh, uh, the activities which are connected with emotions and beliefs and sentiments. There are another aspect of administration, keeping accounts, finance, management, etc. These are all the secular activities. So for secular activities, the law permits to regulate because there should not be misuse or there should not be a what we can say malpractice. So to that extent only, the law can be made accountable or can control. So by the judgment of Shabarimala, a new dimension was given. Of course, since it is an appeal now, the Supreme Court has to examine it later stage.
All right, sir. This was wonderful. Thank you so much, sir, for this great webinar that we had today. And on behalf of Disha Bharat, I would like to extend a heartfelt thank you to you, Sir Aruna Shyam, sir. Disha Bharat is an organization which is working with the motive to instill know yourself, know your country, and know your culture. Today, we've successfully completed day 5 of the 6-day series. And tomorrow, we will have another insightful session.
Thank you.
Thank you, sir. Thank you.